Ladies and gentlemen, welcome to today's webinar. Today's presentation seminar is on the U.S. taxation of trusts, domestic and international. Our presenters today are attorneys Gary Forster and Brian Page. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the question section of the webinar interface. Okay, let me turn it over to our presenters. Go ahead, Gary and Brian.
Thanks so much for attending. Today's topic is a very general topic. We cover a lot of information to give the listeners a flavor for how trusts are taxed by the U.S. government, both domestic and internationally. This is a very interesting topic because you have to run through a lot of background factual issues before you even know how a trust is taxed. You have to determine whether the trust is a U.S. trust or a foreign trust, and you may be surprised at what trusts are called foreign trusts. In light of the fact that it's a generalized seminar and we cover so much material, please feel free to ask questions. We're going to go ahead and turn off the camera so you can see the slides in full and move to our summary of what we're going to cover today. We look at an overview of how taxation works with respect to gifts and estates, how trusts work in terms of estate and gift tax, and then we also look at the income taxation of trusts. By the way, there are classes on, for instance, the estate and gift tax side of trusts that last a semester. And the same is true for the income taxation of trust. So feel free to ask questions. We're going to hit some interesting points. We'll try to interject some ideas and issues that are commonplace to some of the structures. And I'm going to turn it over to Brian to start some of the background in terms of the technical side of the estate and gift tax.
Thank you, Gary. To start with, just as an overview, to give you an idea of the U.S. transfer taxes, there are 3 at the federal level and 1 at this, perhaps at the state level. Most individuals are familiar with the estate tax, the death tax. When you die, if the size of your gross estate is larger than a monetary amount, which is the unified credit, that there is a tax imposed on the value. That's the estate tax. The gift tax is when an individual makes a gift during life or a transfer, and it's unified, so the credit amount is the same. So during at death or during your life, you can do it during lifetime. But if you make a gift, the person who makes the gift pays the tax, and the person who receives the gift gets the entire amount of the transfer. That's different than the estate tax.
And that decreases the credit. So when you die, you'll have less credit if you make taxable gifts. And we're going to hit a couple of points that actually alter those rules when we talk about certain offshore gifts. But that's the general rule, that you make them during your life or you make it at death, the same credit applies, the same tax rate applies.
And then lastly, there's the generations skipping transfer tax. This is Congress thought in 1984 it was unfair if you're mega wealthy to make a transfer to your grandkids or great grandkids. So they decided to impose another tax, basically another estate tax, if you skip a generation, if you make a direct transfer. That's what that is. And then lastly, at the state and local level, not in Florida, but elsewhere in the United States, states have imposed an inheritance or an estate tax. At times, it used to be they were unified with the federal, but now that's not the case. So that's a state-by-state issue. You need to be aware of it.
It can be very onerous too,
especially in the Northeast. We have a unified tax structure, which means that be it for the estate or gift taxes, there's one credit. So an individual in the United States can give up to $11.58 million in 2020 and not pay any tax. which is a lot of money. Historically, it was much lower when we first started to practice law. Right now,
Oh, it's wildly high now.
650 when I say, I think.
Yeah, I mean, we get to the point now where we really are dealing with highly wealthy people before the estate tax or a gift tax even applies. That being said, with our highly wealthy clients, in light of the fact that we've got such a block of credit now before the estate or the gift is taxed, and we can take appraisals and we can make discounts of through different types of entities. I mean, you can get very large estates down under that credit, and we do this day in and day out, but we still see very, very large estates highly taxed because the planning just wasn't there. It's a great time to plan with respect to this credit because you can get so much out and still retain, in most cases, all the income you could ever need.
And right now, this unified credit, also known as the exemption amount, it is indexed to inflation. So it will go up each year until 2026. Will revert back down to 5 million under current law, indexed to inflation. We estimate it probably be around 6 million at that time if they don't change the law.
Yeah, it'll be about half of what it is now if they don't change the law. Of course, with political change comes the change in unified credit. It's bounced around a lot, this unified credit, because it's not that significant a negotiating chip for either side. So one of the first things to change, a lot of times they look at the unified credit because it really only affects the highly wealthy.
And then lastly, there's the annual exclusion amount, which for 2020 for annual gifts is $15,000 per individual.
Yet no return required. It's basically does not interfere with your unified credit. At least once a week, someone will ask Brian or I, what happens if I give more than 15,000 because they're worried about the estate and gift tax. It's not that you're taxed above the 15,000. It's just that if you give a gift of 15,000 or less, there's no return. There's no really tracking it in many ways. Whereas if you give more, you start to use your credit, and you have to file a return.
It's allocated at that time. The federal gift tax, which is just an overview, is imposed on the lifetime gifts of property. The rates are the same as the estate tax, the 40% over the credit amount, and it's done on an annual basis. Mm-hmm. What's interesting is that there is a difference between the gift tax and the estate tax in the actual math and how you calculate the tax. The gift tax is exclusive, which means that if I make a gift to Gary, let's say I give him $100,000 and I have no,
yeah. You have that in mind? I didn't know you even had that in mind.
Yeah, that'd be great.
Fabulous.
That'd be great. And I have no credit left because I'm mega wealthy, of course. What happens is that I, as the donor, am responsible for the gift tax that needs to be paid. Gary gets the entire amount of the gift. If I die and I give him $100,000 as part of my will or my trust, and I'm out of credit, the tax, the estate tax, comes out of his $100,000 gift.
Yeah, and it's a very significant planning issue. We don't want to spend too much. We realize there's a number of people listening. Actually, we've gotten these record number of attendees, and some are highly sophisticated. Some are just brand new to any idea with estate and gift tax. But what happens with these differences, the gift versus the estate, the foreign versus the domestic, is that they create planning opportunities. So if you give a large gift and you owe the tax as the donor, well, you've kind of given two gifts, right? You've gotten more out of your estate, the assets out of your estate, and the donee does not have to pay tax on the gift. The same is true a lot of times with estate gifts and trust gifts, where we can play around structuring these things such that more assets come out of the taxable estate and less assets are taxed, either after post gift or post death. It's just something that you should always be thinking about with whether I make a gift now, whether I wait till I die, what if I'm offshore, whether I make a gift while I'm offshore, or whether I make it when I come in. Is the trust disregarded, etc.
GST tax, I'm just going to breeze by this. It's when if it applies, the credit amount actually is the exact same as the unified credit. So you can make a gift to the grandkids at the same amount of the credit amount and it's okay. But anything above that, you will have an additional tax on top of the gift or estate tax that's imposed. There are three types. A taxable distribution is just a distribution from a trust or estate to a person that is one generation below the grantor. So a grandkid or below is taxable if you don't have any credit. A termination is when the trust ends and there's a distribution, and then a direct skip is a direct gift. That's transfer taxes. That's subtitle B. Now we're in subtitle A, income taxes. The taxation of trust is governed by subchapter J in the code, and it gives you all the rules, the definitions, the difference between different types of trust. They're taxed differently, simple trust versus complex ones. You have the accumulation tax rules, and you have the grantor trust rules. As a basic rule, all trusts are, in general, are a distinct tax-paying entity. So unless they're a grantor, they will file a tax return each year.
Grantor means that the trust is disregarded for income tax purposes. It's viewed just like the grantor, the person who funded and founded the trust. It's just that person who pays the income tax, which is a huge planning opportunity, because sometimes we can create a grantor trust. Okay, this is income tax now. It's unrelated to the gift. So the gift goes into trust. The gift is out of the estate, but the grantor retains sufficient control or powers over the trust such that the actual income developed by the trust, earned by the trust, is taxed to the grantor, not to the trust. So it creates what? Another gift that's not taxable. If the grantor pays the tax on the income, that payment is not coming out of trust assets and creates another gift outside the estate. Very, very common planning where we talk about, do we want to be grantor? Do we not want to be grantor? It just depends on the situation. Typically, if we're trying to get more and more assets out of the taxable estate, we want to go grantor.
It's also important too, because if the trust does not distribute the income in a given year and it retains it for the benefit of the beneficiaries, the tax structure is compressed for a trust. So you're at the marginal rate at basically $13,000.
It's like a penalty when the trust has to pay the income tax because the rates are terrible.
Right. Now, for domestic trusts, taxation-wise, there are two types for income tax. There's a simple trust and a complex one. Simple trust must have three requirements for it to qualify. It must distribute all of the fiduciary accounting income in a given year. It cannot provide for any charitable gifts or set-asides, and it cannot distribute corpus. The most common of these would be something like a Q-tip.
Qualified, marital trust.
A marital trust, all the income.
Right, so all the income goes out. It's very simple. No corpus goes out. It's very simple to account for. It's taxed on a very simple basis. It's obviously less common because you can't distribute corpus. Go ahead, Brian, with the complex.
And then complex is any trust that fails any of those rules, one or three, all of them. And that means that the complex trust can retain and accumulate income inside, and then that will affect the taxation of what happens if it's distributed or not.
It's the reporting's more complicated.
Interesting enough, just be aware that if a trust has income, even if it's distributed out, a return has to be filed, even if it's just informational, because you need the K-1s to push out the income. They have deductions in lieu of a personal exemption, and then as you can see by the low amounts, this was passed back in 1954 and has not been indexed to inflation, so it's very, very small.
Might as well say zero.
Yeah, $100. Yeah, that's
just eliminated.
Wow. Okay, basic rules here. Again, we're just going to go real fast. Distribute income in a calendar year. That's it. That's what a zippled trust must do. You can't distribute principal or accumulated income or make any charitable distributions. The deduction that the trust receives on the return is equal to the amount that's distributed out on the K1. And of course, the beneficiaries must report it, and it retains its character when it comes out. The complex, it's a little different, allows you to sprinkle the income, so you're not required to distribute all in one year. You can distribute income or principal in a given year. The trust will receive deductions for the income actually distributed in a year. And if income is distributed out, the bennies must show it on their return. Beware, if a trust accumulates the income from a prior year and you make a distribution of income that exceeds the annual income in a given year, there could be another tax, the accumulation tax. Just need to be aware of that. Okay, now that we have the broad rules for both transfer and income taxes, now we can talk about foreign trusts. What happens? U.S. persons, which include trusts, are subject to income on their worldwide income, the tax. So if you have income anywhere over the world, you're taxed on it. You must report it.
And the foreign trust is basically considered a foreign individual.
Right. The estate tax applies to any U.S. domiciliaries or citizens, and again, it applies to their worldwide assets if they make a transfer.
Right. So this seminar is not going to go into tremendous detail on how the income and estate tax works for individuals, but you have to understand it to understand the trust, because we're actually covering both foreign and domestic in this seminar, if that's possible. But the idea is we have income tax and we have estate tax, and they're both considered to be worldwide coverage if you're a resident, but the standard for being a resident for income tax is different from the standard associated with being attributed with worldwide estate tax liability. And those standards have to be very carefully monitored, because the individual can be subject to one and not the other. And that also, again, allows for tremendous planning, where an individual, for instance, can come in and be subject to worldwide income tax, yet for estate tax purposes, let's say most of the assets are not in the United States, they're not subject to the estate tax, even if they were to die in the U.S. So it gets fairly complicated, but you just have to, as a general rule, you have to keep in mind that these are two different taxes, and that the standard for their application to non-citizens is totally different.
Right. Income tax usually is based either on you're a green card if you're a non-resident,
Green card holder.
Or the substantial presence test.
Right, which is a weighted average of time in the U.S. So if you're a citizen, you're done. You're subject to both the income and the estate tax. If you're not a citizen and you have a green card, you're subject to the U.S. Income tax. Even if you don't have a green card and you're here for 183 days, you're subject to income tax that year. And then beyond that, if you're in and out of the U.S., you could become subject to the substantial presence test, which is an average of 183 days over the course of 3 years. It's a weighted average, the current year being the most weighty. So you just have to run that. Right now, we're actually running that, probably more than we have in I don't know, I've been doing that for 27 years because we have issues with exemptions associated with time in the U.S. where people didn't expect to be in the U.S. for that much time. And is there an exception for a variety of reasons, medical, etc. And so the idea is people are terrified because if they have to stay in the U.S. for too long, all their incomes, we deal with people with most of their income is like in Brazil, it becomes subject to U.S. tax. It's going to change all of their tax liability. So it's very significant to follow the income tax rule. The estate tax rule is more tricky, I think. It's more tricky because you have to be here for some period of time. Then you have to intend to stay, whatever that means.
Right. So it's based on domicile, which is physical presence plus an intent to remain.
So when people are audited on an estate tax issue, estate and gift tax issue, you know, let me tell you how many people tell the IRS that they actually intended to stay if it creates estate tax. 0.
Every time.
No one, for some reason, no one intended to stay, when they died at that point. They just really didn't feel like staying. They just happened to die here. So that's the issue, where it becomes a facts and circumstances issue of, what are these factors that show that they intended to stay here, until they died, which, is basically a circus at that point. So you want to establish all the planning you can, all the evidence you can, if it's required, that you really intend to go back home in terms of the estate tax.
You might also think to yourself, why is this important? Well, these are foundational things to understand the effects when you have a foreign trust about when is it created, what your status is, because it might be taxable or have taxation at different steps along the way.
Yeah, I mean, some of these cases have come down to really silly things. It's kind of random. I mean, they find a return ticket. Oh, he had a return ticket. He meant to go back home. I mean, anything helps at that point. The cases are everywhere because no one knows what to do. But planning in most circumstances can eliminate that.
We have a question.
Okay.
So if a taxpayer transfers money to an irrevocable trust with 2 children as beneficiary, is a gift tax return required? Are the 2 children the donees on the gift tax return?
If it's an irrevocable trust, if you want it to qualify for the annual exclusion, you have to issue a crummy letter in that year, which means that you have to give them notice of a right of withdrawal or their guardian if they're minors, and that's under the code. And if the time passes, then it qualifies for the annual exclusion amount, and you would not have to file a return. If you make a gift that exceeds $15,000, or I should say, if it's for 2 kids each, so over $30,000, even if you did a crummy letter, then you would have to file a 709 for any amount that exceeded the 30,000.
It's gift to trust.
It's a gift to trust, and you would allocate your credit. A tax would not be due if you had credit, but you would have to, actually use it or like harvest it, so you don't have to pay tax. But a return would be required.
Mm-hmm. And then when you exceed, the 11 million, if you're that fortunate, then you actually would have to pay tax out of pocket.
And there's an automatic allocation. So there are times when individuals might not want to pay it, but there's a special form to pay outright if you want to and use your credit later.
Oh yeah, you can, right, absolutely. Yeah, save the credit. They have the exemptions. So foreign non-US persons, that's so on the income tax side, non-US persons, so you don't have a green card and you're not here to satisfy either the annual or the substantial presence test. You're taxed basically on US source income. Things with income with a situs in the United States. There are some pretty good exceptions though, and the big one is the stock sale exception. Basically, if you sell stock in a U.S. entity and you're not and you're not a U.S. income tax resident, you don't have to pay capital gains tax. It's a very unknown, underutilized exception. In reality, foreign people and these financial centers are very aware of it, actually, and they trade U.S. stock at no U.S. Capital gains tax. Treaties will reduce the income tax or the capital gains tax. We have on the slide the 30% withholding on passive income. So if you have income on, interest, on rental, passive income type stuff, it's called FIDAPI, fixed regular income. It's subject to a flat tax, which if you're old enough, you remember the push to a flat tax, and that's a 30% rate. There are some exceptions to that for like rentals. You can make an election so that if you have a lot of costs coming out of your rental, you can take a deduction. But in general, it's a 30% flat tax, and you basically have to plan around that or figure out what's the best format for you as a non-U.S. person. And as Brian had mentioned, foreign trusts are non-U.S. people.
That's right. So for them, unless the income is connected to a U.S. real estate gain or effectively connected to income where basically it's something that's producing income in the United States.
Well, business.
And then
or passive. Business is taxed actually at graduated rates.
Right. It's effectively, yeah, right. And then a U.S. beneficiary would be taxed on the income from foreign trust when they receive it from the foreign trust. The estate tax is a little different, but the main exception, any U.S. situs property, it would apply to the non-resident alien who makes a transfer, except for intangibles.
Yeah, what's interesting about that is if you gift intangibles, which is typically stock in a corporation, you gift U.S. situs intangible, that is not subject to gift tax. But when you die, if it's U.S. situs like a U.S. corporation, it's subject to estate tax. So all that stuff should get gifted out. But in reality, you can avoid a lot of these issues by just creating a foreign entity, and that foreign entity holding your U.S. situs assets if you're not a U.S. resident, income tax resident or estate tax resident. And that basically what happens is when the individual dies, the foreign entity doesn't die, and it avoids the estate gift tax.
This is important because non-resident aliens only have a $60,000, unified credit amount to offset the value in the United States.
So you kind of have to get people moving down the right path. For instance, we had a group contact us yesterday from Turkey. They've, for whatever reason, they've already bought a substantial amount of property in the United States in their individual name. We can unwind this. In other words, the idea is to move that property into a foreign entity such that when the ultimate owner of the property dies, the foreign entity doesn't die, and we don't have an estate tax issue. The problem is that if you start on the wrong foot and you go ahead and start purchasing properties in individual name, you run into a number of obstacles that require a lot of time to deal with to now unwind that property out of individual name and get it back into the name of the foreign entity so that you can avoid the whole estate and gift tax net. That's true because what happens with the sale or transfer of property by a foreign individual is that it's regulated by FICPA. And what FICPA did, I think it was in around, I want to say it was in 91, 92, where foreigners could sell stock in entities, and that's still the case, U.S. entities, and not pay tax. That's the sale of intangibles, sale of like stock on the U.S. Stock exchange, and not pay capital gains tax. There was an exception made for real estate, and that was called FIRPTA, the Foreign Investment Real Property Act. And unfortunately, that FIRPTA now subjects all the transfers by a foreigner of U.S. property to this encumbrances and tax. And then if you go ahead and buy all these properties in your individual name now, before we do any planning, you're subject to FIRPTA on the transfer back out of those properties to the foreign entity, which is the planning part, so that you're not subject to the estate tax. It can take six or 8 months. And now we have currently we have even further delays. So it's not that hard to do it, but instead of jumping in, if we have a lot of CPAs on the call, instead of jumping in and starting things and then sending us an email that says, I'd like to do my estate planning in the U.S. because I own a lot of property in the U.S. and I'm never going to enter the U.S. and I'm foreign, instead of like assuming it's an estate planning matter, let's go ahead and look at it before you close on the property, so that we can structure it so that we don't have this huge FIRPTA, obstacle.
And the effects are large. We had a client, a husband and wife from the UK, that bought a house here in their individual names, and the wife died.
Oh yeah.
And half of the value was a $4 million, whatever it was, a large home. I don't know exactly now, but
it was 800,000 in tax for half. So you don't have the marital transfer of unified credit for non-U.S. people. So the mom died unexpectedly, and the IRS showed up, $800,000 bill. Absolute waste of money, because they never would have had to pay that had they structured that right.
So the taxation of foreign trusts, international trusts, is important because these rules apply to the grantors or settlors, the trustees, and potentially the beneficiaries, as relates to substantial reporting requirements and compliance on an ongoing basis once they're prepared. And that's something that's lost at times. Also, when individual forms a foreign trust, there might be tax at the time of the creation of the trust, when income is made, or when distributions are made. So it's important to know factually how this works.
Yeah, it's kind of we have to take, it's not so much, we have to take the facts into account, and then not so much the current facts, but how we can change the scenario, right? What's available in terms of change? Where can you move to? Where can you spend time? Where's your principal place of business set up? Do we need to change that? And then, based upon what we can change, we create a structure which is most beneficial.
In all these things, all these facts matter. Who the grantor is, where the trust is established, where the beneficiaries are, all those things can affect the taxation of the trust. So what is a foreign trust? Well, under the code, it tells us that a domestic trust, which is a United States trust, must meet 2 tests, the court test and the control test. If it meets both, it's domestic and it's taxed as a domestic entity in the United States. If it fails both or either, it's a foreign trust.
Which also allows for planning.
Which it does. But it can also be a trap at times for the unwary.
Yeah, we have people occasionally. We actually have, last one was like a U.S. group, and they had a foreign trustee. They had one of the members of their family was a foreign individual in Holland, and that was the trustee. So they actually had a foreign trust. So they actually were out of compliance on the trust because they had a foreign trust.
Things like that.
Crazy.
Now, why is it important? Well, if you have a foreign trust, 2 potential events occur. If you're a U.S. resident, either a citizen or a green card holder, and you prepare establish a foreign trust and make a transfer, The transfer itself, depending on the terms of the trust, might be a gift. It might not be. But if it is a gift, the general transfer tax rules would apply. You'd have to apply your credit. If it exceeds it, you would have a tax, the gift tax. There's also an income tax component,
which is very complicated. Very, very complicated.
In the Congress, in its wisdom, decided back in the mid-90s that if you put assets in a foreign trust, you were basically expatriating those assets.
Yeah, the general rule is that you're moving them offshore, and to correspond with the expatriation tax law regime, which was different at the time, actually, that this was enacted, it's a deemed sale. It's as if you put that stuff in there, and even though you know you may not have intended it, you may have done your gift, whether or not you did your gift, it's as if you sold all the assets. You have to pay capital gains tax. That's the general rule.
Right. And the exception to that is during the lifetime of the grantor, if there are U.S. beneficiaries of the foreign trust that during the lifetime of the grantor, or as long as the foreign trust has a U.S. beneficiary, it's treated as a grantor trust for income taxes.
Right. As long as there's a U.S. beneficiary, what happened is they eliminated the ability to create a non-grantor trust. Remember, the grantor trust is, for income tax purposes, is disregarded. So it's as if all the assets are owned by the grantor. They're not owned by the grantor. But what that means is any income created by trust assets has to be payable by the U.S., in this case, the U.S. grantor. It's basically a grantor, and then trust has to have a U.S. beneficiary. We do a lot of foreign trusts. So as you could imagine, if you have a U.S. individual that does a foreign trust, they typically want to be a beneficiary of the foreign trust. It's usually for protective purposes. And at a minimum, their kids who are in the U.S. are beneficiaries. So this rule creating grantor status is very common for U.S. people that form a foreign trust. For foreigners, it's a totally different format. I'm not sure we covered that yet on this slide. That may be the next slide. But if you're foreign, you may not have a U.S. grantor, and the rules associated with disregarded tax status are completely different.
And it's important because this delays this deemed sale. If this 679, if it's a deemed grantor trust, if you have a U.S. grantor and a U.S. Benny, it prevents the mark-to-market sale on the transfer of assets.
That's right. It's grantor, and remember, what you did on the estate and gift tax side is separate. So where the general rule is, you move stuff into a foreign trust, it's as if you sold the stuff, you got to pay capital gains tax. Well, if you have a U.S. beneficiary, U.S. grantor, no, not yet. We're just going to disregard the trust for income tax purposes.
Right. And then either at the death of the grantor, the earlier of the death of the grantor, or the trust no longer has a U.S. beneficiary, at that point, the 679 status being a grantor trust extinguishes and 684 would apply. That's the general rule. The exception to that, which would avoid the tax, would be is if it was an incomplete gift of the grantor and it was pulled back into his taxable estate, he would have a step up in tax basis and there would be no tax inside of the trust because it has a fair market value basis.
That's right. So if the assets weren't removed from the estate, this is a U.S. grantor, so they stay in the estate. So what you've done is what? You've created a foreign trust for protective purposes. You haven't done any estate planning immediately. There's no gift, so there's no gift tax or reduction of your credit. And because you have a U.S. beneficiary, there's no income tax. So you've done nothing on the estate and gift tax side or on the income tax side. It's just as if the grantor owns it. Then when the grantor dies, that grantor status ends. It's a deemed sale, but what happens? You got your step up in basis because the assets are still in the grantor's estate. Where we see errors made actually is where the foreign trust is used for estate tax planning the intent is that it's used for estate tax planning. So the assets go out of the estate, right? And then there's a death, and then we don't get the step up because the assets are outside the estate, and the mark-to-market tax associated on the income tax side, because it's no longer a grantor, can be pretty onerous.
Right. That's right. And this income tax 684, as Gary has already said, is totally separate from the U.S. transferred taxes that may or may not apply on the initial transfer or at death. I mean, they're two separate things. That's A and B under the code.
With the estate tax, not in this. With you got to do the separate calculation, but if the assets are out, all the other assets you're going to get hit with the estate tax. You may have already paid a huge gift tax, and then you've got to pay as if you sold the assets. It's going to be a lot of tax. I mean, a huge amount of unexpected tax. And we'll talk about that's the U.S. side, and we'll talk in the subsequent slides here on the foreign grantor side.
If a foreign individual creates a foreign trust and they put foreign assets inside the trust, there's no U.S. estate or transfer tax.
There's no link to the U.S.
There's no link. So that would be respected under the tax code, income tax wise, as an NRA with certain modifications as relates to income.
Which allows for a lot of planning, because the assets come out, it's not related to the U.S., so there's no U.S. estate or gift tax. But maybe one day that grantor intends to actually come into the U.S. If we plan early enough, we can avoid that whole estate tax net.
But if they don't plan and they come in, the assets inside the foreign assets inside the foreign trust will not be subject to the U.S. transfer taxes, but they may be exposed to the U.S. income taxes
with the mark-to-market.
With the mark-to-market. And so, overview for pre-immigration planning: if a person wants to, come into the United States, they have foreign assets. They want to do planning before they come in, because otherwise,
bring the assets into the U.S. estate tax.
Right. Otherwise, you're going to bring those assets, the worldwide assets, into the tax base.
It's a very common issue.
Income and estate. So there are some planning opportunities here. The main rule is that if a foreign individual creates a foreign trust and then they come into the United States within the 5-year period from the date of creation and funding, then the tax code on the income tax side says that we're going to deem that as if you made the transfer on the date that you established your residency here. So 684 or 679, depending on where the beneficiaries are, this is going to apply this regime. So if you have U.S. beneficiaries, if it's the person themselves or their kids and they're here, then it's going to be a grantor trust until their death.
It's going to be considered grantor for income tax purposes, so that grantor will pay all the tax. The problem is that person will die at some point, and at that point, the estate's going to face the mark-to-market deemed sale of all those assets, and there's action that can be taken on that with respect to the domestication of that trust, making it no longer a foreign trust. But a lot of this goes on without basically people benefiting from advice. People think in general that, well, I have to have 10, 80, $100 million, 200 before this stuff starts to impact me, but it's not true. We have a huge amount of clients, that are wealthy, but not wildly wealthy, and it does impact them. It can still impact them, especially on the income tax side.
Income tax side.
There's no exemption or anything.
Right. Now, when you have foreign trust and you have NRAs, treaties may affect the taxation. Just need to be aware of that.
Yeah, you always have to look at what the treaty says before we go into all the other rules, especially on the income tax side. Sometimes you'll have a domicile-based estate tax treaty where only one country will tax, and that's typically where the person is domiciled. And those are great. I mean, we take advantage of those all the time. And sometimes you can plan. Maybe one regime is less taxed than the other, and only one regime will actually tax. Well, we want to end up in the cheap regime. Let's end up resident, of whatever Spain instead of the U.S. and we don't have to pay as much tax, or whatever the particular situation is. Treaty planning it can be very, very, very helpful.
Some of the last things, we'll cover this fast. If you do have a foreign trust, there are some forms that have to be filed with the IRS annually. The main one is Form 3520. If you have a U.S. resident who creates a foreign trust, they must file this annually. So you need to be aware of that, and it's due at the same date as their Form 1040. And that includes the extensions. Understand that there will be a statement that's attached to this that's on the next form I'm about to talk about, which is Form 3520A, which is completed by the foreign trustee.
Very significant. By far the most significant form is the A, which is basically a financial disclosure.
And it's due a month before the individual's income tax due, so it's due March the 15th. And it's important because this is an informational return for the IRS. They also will distribute to the U.S. grantor, the owner, deemed owner, and the U.S. beneficiaries a statement that they'll attach to their individual returns.
Right.
So it's important that this is done. And if it's not done, the U.S. grantor is still responsible. So you need to be aware of that. And then if you were a U.S. beneficiary, you have to file the 3520 as well each year. So just you need to be aware of that.
We find that,
no one ever does this. Just be aware of it. It's there.
Unless they're really planning, they just don't do it.
The other things that might apply will be Form 8938 under FATCA. If you meet the thresholds, U.S. residents will have to file these informational things with the IRS.
This is anybody.
Anybody.
This is anybody, including basically individuals with accounts or assets offshore.
And the same thing with the FBARs. You just need to be aware that they're there. $10,000 is nothing, so you probably have to file it every year.
Yeah. We had a few slides on trust and asset protection. We have a couple of minutes left. The main driver of domestic foreign trusts created by domestic individuals is asset protection. Basically, we have some of the basic branches of asset protection that have to do with how things are titled. In Florida, for instance, we have a husband and wife titling that allows for protecting assets in a very basic way. If we have a claim against a husband only or a wife only, those assets are not available to the creditors. We have exempt assets, which is like life insurance, the homestead, or if we buy them before there's any trouble going on, they're not available to the creditor, to someone who sues you. Trusts, we basically, trusts are the oldest form of asset protection, and the way they function in general is that trusts divide title between beneficial owners and legal owners. So a grantor appoints a trustee with legal title to assets. The trustee has no right to benefit from the assets, just to manage the assets. So if the trustees sue, those assets are not available to a trustee's creditors. And the assets are placed in trust for the benefit of a beneficiary. But the beneficiary, if the trust is properly drafted as discretionary, that is managed truly by the trustee, entirely by the trustee, beneficiary has no right to reach the asset unless the trustee agrees. So if someone sues the beneficiary, those assets are not available to the plaintiff. This is good for an asset protection, reasons associated with the stability of those assets. They're not really available to anyone. Parents can make gifts to children, and if children get into trouble or become liable for anything, themselves in general. The trust statutes vary from state to state, and offshore they vary pretty significantly actually. But the idea is that, you know, parents can give to their children and those assets are not available, that, you know, there's a negative connotation to the trust fund baby. Now that the trust fund baby has all the assets, the trustee provides for the lifestyle of the trust fund baby, and no one can ever reach them. So you may have a bad actor that doesn't lose these assets. LLCs are not trusts. They're business entities that basically limit a plaintiff to a lien on LLC equity, except for certain circumstances, including what's become known as the single member LLC. Those may be subject to foreclosure. But the LLC is different from the corporation. The corporation stock is totally exposed. I think we're starting to run out of time. We just want to give you a little overview of, you know, why people actually form these things apart from the estate and gift and income tax planning. So it's really, we look at it from a global perspective.
And if anybody has a question, now is the time to type it into the question section.
And we'll turn the, yeah, there we go. So we are live. Here we are. If you have any questions, just type it in. If you want to contact either myself, Gary Forster, or Brian Page, our contact information is on the last slide. If you'd like a copy of the presentation, or, you know, we also have outlines of these presentations. If you want, you know, like materials to send, if you're a lawyer and you need to send it to your state bar, et cetera, to get credit. We pretty much always are able to get people credit in Florida. Just let us know anything you need. If a question comes up, we love questions because they end up creating trust between either the client or the advisor and the firm. We talk, I'm basically on the phone all day with people with questions. This helps us, you know, with business. It helps you, you know, satisfy your client if you're a CPA or financial professional. We have a couple of books I've written on this. Brian and I are working actually on a foreign trust book. We'd love to send that to you, whatever, you know, whenever you like. And we thank you for attending today.